So going through this very quickly, you've got the a copy of the PowerPoint in your paper. I want to get to the end. At the end, I'm basically going to say that I think we're at a stage where we will recognize caring as a human right, a fundamental human right. Now, I'm saying that not as a starry-eyed academic. I've spent quite a lot of my life in the European Court of Human Rights arguing cases. And so what I'm saying is I think courts would accept this. And in fact, courts are already accepting that in cases we see coming before the courts in Canada and in New Zealand. Disabled people, as I've said, in the 70s in the UK, but most places, they were simply the responsibility of social services. They were ill, they needed support and sympathy, and wasn't it terrible, wasn't it tragic? And they were just, as I say, handicapped cripples that you sat there. This sort of sympathy model they challenged. They needed looking after. It was a very paternalistic approach to disabled people. And the reason I mention those points in the article is because I'm going to echo those, because I think we're not far from that with carers at the moment. The Dusty Take Sugar came on in BBC because the disabled people's movement was growing. Disabled people movement grow. Most human rights emerge out of war. Women's vote comes in the UK after the First World War. Disabled people's rights come because of largely Vietnam, large numbers of disabled Americans, highly educated, returning and being very angry. I argue in my paper you need three things. You need the identity, you need the development of an identity, a disabled person's identity. You need a narrative of oppression, and you need a creed. You need a banner, basically. Disabled people, it was always a problem with self-identification. If you read, and I quote quite a lot of the authors in the paper I've written, they didn't want to say they were a disabled person. They wanted to say they were a mechanic, they were a law lecturer, they were something else. So identification has always been a problem with oppressed groups. And we see that particularly, obviously we see that with carers. They're not saying, I'm a carer. But that's not unusual. But what we saw in the 70s was a burgeoning number of disability rights organisations throughout America, then Australia, because of course Australia didn't keep out of that particular war. And in the UK, it was about the only war we've ever managed to keep out of, Vietnam. And then it proliferated with this vast growth of disabled people's organisations. But again, of course, we're witnessing that extraordinary growth in carers organisations. Until recently, the only thing you didn't have with carers organisations was an international organisation. But of course, that's why today is such a fascinating moment for me. You needed a narrative of oppression. Well, of course, with disabled people, that's not difficult. Institutionalisation. And far worse. Obviously, I've written about how we used to routinely kill disabled children in the UK until the 1980s. And of course, we've had eugenics and things like that. So it's not difficult for that with disabled people. But you needed a creed. And of course, the creed came from America, but also the UK, which was that medical model of disability was wrong, that people were not incapable of doing things because they were crippled because of their medical condition. They were handicapped because we created barriers. They couldn't access things. This man here, this is a classic picture on the classic book on the subject, and the man cannot vote because of the physical environment able-bodied people have created. So able-bodied people, non-disabled people, handicapped disabled people. And I remember in the 70s, I mean, when I grew up, there was no discrimination legislation at all in the UK. And when I was just entering high school, we got race discrimination. And when I finished university, we got sex discrimination. And in 1995, we got disability discrimination. But in the 70s, when I was a lawyer, if people had said that disability would be the next status to be protected, I'd say don't be silly. I mean, I really wouldn't have got disability as something that you shouldn't discriminate against on. Because sex and race, well, they're pretty obvious characteristics that should be irrelevant, although obviously both were contested. But there's a lot of things disabled people simply can't do, and therefore it is quite reasonable that you treat disabled people differently. But of course, and to say that disability was a human rights issue, would you just have said, well, don't be silly. Human rights are about slavery and torture and freedom of expression and things like that. Disability is just a tragedy, really. Then, of course, because of the Americans' movement, we have the US Rehabilitation Act, and then we have the Australian with Disability Discrimination Act, then we have the UK Act. I remember writing doing some work on disability in the early 90s, and we were just charting the number of bits of law that were recognising disabled people discrimination. All of it seeded by the Americans' legislation. And it was about 23 or something in early 90s, which seemed a lot. And of course, within 5 years, virtually every country in the world had that legislation. It just grew exponentially. If we look at today on carers, we'll see that we're almost at that 23 level about non-discrimination legislation. It's going to go up. We've now got a European Union directive on this, which is a sort of international directive, and now we've got the UN Convention on the Rights of Persons with Disabilities. So within 10 years of us beginning to get this tipping point for discrimination legislation, we end up with a UN Convention on the Rights of Persons with Disabilities. It's the quickest ratified UN Convention in history, and uniquely, America has signed up and ratified it, which is very unusual in international terms. Not because America's a naughty country, but it has political difficulties in ratifying international conventions. Now, what I'm saying is we could just run that story straight through again for carers. Carers are in the UK and in most countries really just dealt with by social care. They might get some social security supports, but they're basically the responsibility of one limited arm of the state. They get sympathy out, they're doing wonderful, and one of the big things I cite a lot is that they get this sort of tokenistic opiate support, a little budget here or a little budget there. You know, yeah, it's great to give somebody 1,000 euros a year, but they're saving, you know, the country hundreds of thousands of euros. And so even a lump sum of 1,000 euros is highly tokenistic compared to the loss of a pension of a whole life. But to be a rights movement, carers need to have, it seems to me, the development of an identity, a narrative of oppression, and they need to have a creed. In the paper, I spent a lot of time looking at the identity issue because, of course, carers are not self-identifying. They're not saying I'm a carer. They're not putting their names down on censuses as carers. But that's not difficult because we have the same problem with many other oppressed groups, gay people as well. But we have legislation, and I spent a lot of time looking at the fact that throughout nearly all the world there's a liable family legislation that makes it the duty of family to care. In the States, so that a lot of that comes in the common law countries, America, Australia, New Zealand, Canada, from the UK Poor Law, because the UK Poor Law had this obligation. Curiously, we've abolished it. We're one of the very few countries that doesn't have a liable family rule. But of course, it remained in India and Singapore and other countries. But it was also part of the European Code. So America's got 30 states with the filial responsibility laws. German code has it. Nearly every European country non-British Commonwealth country has it in their civil codes. Because Spain had it, it therefore went to South America. Because Portugal had it, it went to Brazil. And so you can see it in virtually every country. And it's very strong in the Chinese legislation, and it's strong in the Taiwanese legislation. And it's part of the cultural, customary law of Africa. So there's no problem in talking about carers as an identified group, because the states identify them in law. There is a burgeoning amount of legislation recognising carers as well anyway, and we've heard about that this morning. They're actually named in the legislation of dozens of countries, from Colombia to China. And I list as many of the bits of legislation I can in this pretty dense paper that you've got. And there are widespread compensatory measures about which we have heard as well. So they formally have status. And we've heard about the stark evidence of the appalling situations that carers live under. Carers UK and the UK have done enormous work on this, and you've all doing similar work in your own countries. And the UK government itself accepted that they're one of the most socially excluded groups. So we move to the issue that we've got to now, because first of all discrimination comes and then human rights come. First of all you've got the disability discrimination legislation, the Americans with Disabilities Act, then you get the UN Convention on the Rights of Persons with Disabilities. And so what we're arguing largely now is what we would call derivative discrimination or associative discrimination. And that's been recognised in a number of countries now. And there's a very substantial European Court of Justice case on this, that disabled people, that to treat carers badly is to be associatively discriminating the disabled person. And so, as Madeleine her talk said, the Equalities Act now protects carers. The French legislation protects carers, the Colombian legislation protects carers, and the Australian legislation, if it's enacted, which probably won't be, but would have protected carers. So, and of course carers are seriously, I mean in this case the carer could run in and vote without any difficulty. But if the carer wanted a CT scan, or the extraordinary case Frank was telling us about, then the carer's got to do all these extraordinary arrangements before they can go and get their dental treatment, or for students studying. It's a big issue. So we've accepted that. There was huge resistance. People said, well, no, I mean, it's obvious that disabled people shouldn't be discriminated against, and women and racial groups, because those are innate. You can't do anything about it. But caring, I mean, it's choice, isn't it? You know, and that's not innate. But of course, that's not really, doesn't work anymore, because of course, many young carers don't choose to be the children of parents with mental health problems. I do a lot of work with parents of disabled children, and they didn't choose to have disabled children. It wasn't a choice. But in a way, in legal terms, that doesn't really matter, because although sex, race, disability are innate, and age, which is another protected characteristic, is innate, and you could say sexual orientation is innate, although there are arguments on that. Those are innate categories, but we've now recognised most of the world that you shouldn't be discriminated on grounds of religion. And religion is not, in my humble view, necessarily innate. So we've moved beyond that. This is the classic European case, and it's now protected in the equalities legislation and the Australian legislation. So we've got that. Now the bit that I want to talk about for 5 minutes and then open up discussion is, could we say caring is a human right? Because in a way, we've won the discrimination issue. We're going to have this exponential growth in you can't discriminate against carers. Now, a lot of non-lawyers, what I'm doing in this paper is citing an awful lot of non-lawyers. The only thing that I'm bringing to this is that I'm a lawyer, because very few lawyers have never written about human rights and caring, but a lot of social policy people have. And Robin West, particularly American academic, she's written about the right to care. And one of the very interesting things she talks about is, why should we worry about that? What's the point about having a human right to care, a right to care? And I think it sort of, she comes up with a number of very good reasons, you know, just another human right. And she says, well, human rights will endure beyond changes in political debate. Once you've recognised something as a human right, it endures. I'm not a fan of neoliberalism. Neoliberalism is always says, well, make me an economic case for that. If it's an economic case for increasing the carbon dioxide level in the world by 50%, then it's okay. If it, you can make an economic case for these things. I always tell my students, you can make an economic case for slavery. You know, it's probably a very good economic thing. But you can't do that because there's a human right against it. Within the disability discrimination legislation, there were economic cases for warehousing disabled people in institutions. It's much cheaper than keeping them in the community. But of course, once you've got a human rights thing and you say, well, that is actually infringing their human rights, you can't justify institutionalization, you can't justify slavery. Once you can't start saying there's a human right to care, you can't justify punishing people for caring. Once there's a human right to express, you can't punish people for expressing themselves. Well, we live in a world where carers are punished for taking time off work, or they're punished in terms of getting half the pension pots. The Australian legislation, the Human Rights Commission say that pension, you know, the carers are routinely punished by the state for this action. It's no longer the act of a generous state. It's no longer acceptable to slash your budgets. I mean, Frank and Mario this morning and Claire were talking about the fact that because of the financial crisis, things have been slashed. Well, it's easy to slash things that are not embedded in some form of human rights argument. They just say, well, we can't afford it, but we can't start putting people back into institutions because it's too expensive to let them live independently, because Article 19 of the UN Convention on the Rights of People with Disabilities says you can't do that. So it becomes much more of an obligation, much more difficult for countries to just make an economic case for slashing budgets. In the paper, I look at a lot of conventions. One of the most interesting conventions is, of course, the UN Convention on the Rights, Convention outlawing all forms of discrimination against women, CEDAW, because, of course, caring is highly gendered, and women are indirectly discriminated by this. They have much worse outcomes. The International Covenant on Civil and Political Rights and Article 8 of the European Convention on Human Rights is where the right would lie, which would be a right to respect for your private life. Your private life is your interaction with the environment. It's not just your not being photographed. It's about not being denied sort of contact with other people, activities, work, or being harmed in relation to your family rights. And out of this, we get many, many derived rights. We have the right to palliative care. I mean, that's now accepted as a fundamental human right. There are no choices about it. The right to a livelihood, a right to be able to work, and a right in some countries to development. These are all recognised rights, and they are important because those things will withstand the vicissitudes, effectively, of political swings and roundabouts, and also economic issues, because one of the things, the fundamental things about these human rights is there's a principle of non-regression, that even if some of these rights are aspirational, you've got to move purposefully towards that. And if things are hard, you may not be able to move so fast forward, but you can't go back. And of course what we're hearing is a lot of situations, people going back, Ireland cutting its disabled facilities grants. Well, that's only because it feels that it can do that, because it doesn't feel it's anything other than a privilege rather than a right. And in a UK case famously, and there are there are not many cases of this, and it's you'll have this, Lord Justice Mumby, as he now is, talked about the fact that if disabled people have rights, human rights under Article 8, the right to private and family life, then so must carers, because these are universal human rights. So this is a case where in the UK and definitely in Europe, the court would have no problem in saying there's a human right to care. So really what I'm going to finish on is the creed, and the creed comes from, to me, one of the most inspirational writers there are at the moment, somebody called Martha Feynman. She's an American lawyer, and she's written a book called The Autonomy Myth. And what she's saying is, effectively, that just as we've created environments that handicap disabled people, so too have we created environments based on the mythology of independent people, that we are all independent, we can do exactly what we want. And we have, for the last 30 years at least, since we abandoned paternalism in the West, reified, deified independence, autonomy, self-sufficiency. And so we've created environments that handicap people that are not independent, self-sufficient and autonomous. And that's not just disabled people, it's people who are involved in the business of dependency. The people, and it's not just unpaid carers, of course it's paid carers as well. They are low paid, and incredibly low paid. And that is an extraordinary situation to create an environment where we denigrate dependency, we punish people because they're involved in dependency work, when dependency is completely inevitable. For the first 18 years of our children's lives, they're dependent. And of course, many of us will return to dependency as we get older or have episodes of it. And of course, her argument is the reason we have done that, the reason that we have existed in an environment is because we don't value dependency, and we don't value it because we don't compensate it because it's gendered, basically. Not that it's exclusively done by women, but because women largely do that, it is engendered and undervalued. So effectively, the creed, I think, for the carers movement internationally is the politics of dependency. So you have the three ingredients. But what you need for that, finally, is an international organisation. And so I think what you're doing is really historic. I mean, I really do think it's historic. When I was looking at the first stages of this paper, which I've been writing for about 6 or 7 years, there really was no international presence. And of course, we sit here today with, you know, the real thing. Okay, thank you. All right.